All rise.
Lost my colleague, sorry. I started with 3 this morning. Must have been something you said. Good morning, Minister. Sorry about that. Yes.
Good morning, my lord. My lords, my lady. When I broke off yesterday, I was dealing with general legal principles and I'd addressed the Jameson and Middleton cases. From those cases, we draw 3 principles of relevance here. First, in a Jameson case, the key purpose of the inquest is to establish and state the means of death, and the conclusion of the how question must be limited to the means of death. Second, in a Jameson case, a short form conclusion will often be used. A narrative may be used as well or instead, but it must be limited to addressing the means of death. Further, it must be brief, neutral and factual, and the samples suggested by the court in Jameson were illustrative. Thirdly, the Middleton approach is fundamentally different, allowing more extended as well as more judgmental conclusions on broader circumstances and underlying factors. And in a case of suicide, these may extend to steps not taken which might have saved life. And my lord will remember those passages from Middleton where Lord Bingham explained why a conventional Jameson inquest might not satisfy the conventional requirements. Let me then turn briefly to the Hurst case, which stresses that distinction and also addresses its consequences. That authority is at divider 15 of the First Authorities Bundle, page 272. As my lord will recall, it was a case concerning a death by stabbing where it was suggested that the police had failed to prevent the killing. After the criminal conviction, the family wanted an inquest resumed to look into the matter. Article 2 held not engaged on a retrospectivity point because the death occurred before the 98 Act came into force. An issue arose whether the Middleton approach to the how question applies in a case where the Article 2 procedural obligation is not engaged and the majority held not. Lord Brown explained that conclusion and its consequences, first at paragraph 34 on page 293. Letter D, he summarised the view of the minority that the inquest could still examine the conduct of the police, despite Article 2 not being engaged. And then he said at E, given, however, as both Lady Hale and Lord Mance in terms accept, that on conclusion of such an inquest, the jury would be debarred from expressing any views whatever upon the conduct which they've been examining. The whole point of a Middleton inquest being to enable the jury to state their conclusions on the important underlying issues, such as what risks should have been recognised and what precautions taken. The value of such an inquest may be doubted. It might indeed be thought the worst of all things. And then the court there doubting the value of looking into conduct of public authorities, only then not to be able to address them in the conclusion. Then page 297, Lord Brown specifically addressed from paragraph 48 the contention that Middleton applies to all inquests. Paragraph 48, he rejected that argument, first because by letter E, the House in Middleton was not intending its approach thereafter to apply in all cases. And then at paragraph 49, he rejects the proposition that reinterpretation of Jameson generally is required to satisfy the UK's international law obligations. Paragraph 51, it should be noted, that he held that the Jameson interpretation didn't place itself in conflict with those obligations, and he made this comment in connection with the two types of inquest by letter H. Of course, the scope of the inquiry is ultimately a matter for the coroner. The verdict and findings, however, are not Jameson construction of how severely circumscribes these. That's what we take from the Hurst case. Now, since the Hurst case, this court's decided in the Humberstone case, we don't need to go there, that the Article 2 procedural obligation is only engaged in the Middleton sense, where on the evidence there is an arguable case one or more of the Article 2 substantive obligations have been breached. That is, for my lords and my ladies, note authorities, page 5, authorities 11, pages 603 and 609, that the point is not in dispute, so I don't go to the authority. Turning then to the authorities on narrative conclusions in Jameson cases, they have in our submission consistently respected the principle that the conclusion must be limited to the means of death as well as being brief, neutral and factual. We've addressed all the cases relied on by the appellant in a footnote on page 20 of our skeleton. But the high point of the appellant's case is perhaps represented by the Longfield and Worthington cases, to which my lords and my lady were taken yesterday. In each of those cases, the narratives endorsed were limited to the physical means of death. In Longfield, my lords and my lady saw it yesterday, it's authorities 10, page 134, the death was due to bronchopneumonia accelerated by a fall through an open window. And that is what the suggested narrative said. In Worthington, the box 4 conclusion, this is authorities 34, page 869, to which the court was taken yesterday. In Worthington, the death was as a result of inability to breathe, or as a result of the ability to breathe being compromised by an unsafe sleeping environment. That was box 4. And then in box 3, there was a short summary of the baby being placed in that environment, in which the awful facts of the anal penetration were part and parcel of the baby being placed and left in the unsafe sleeping environment.
Well, you say that, but those facts were awful beyond belief, but the thing that physically caused the poor girl, the poor child to die, was inability to breathe. What brought that about is being put in an environment, the adult bed, where she couldn't breathe. But what led to her being put into the adult bed was the dreadful thing that was being done to her. And they still said you could include that. Now, that's not this case, obviously, but by analogy, I'm sure Mrs. Dove would be saying, well, it's the same. It was the drugs that killed poor Jodie. It was the taking them because of her mental state, which was the suicide. But there were a number of things that led up to that.
I understand the argument, but in that case, the placing of the baby in the unsafe sleeping environment was the means of death. And, and the penetration was part of the baby being placed in the unsafe sleeping environment. I accept that the drawing of lines in these cases is difficult, but it would be a step beyond where the courts have ever gone.
So far, right again.
So far, to say that a Jameson inquest can go into the motivations of a person to end their life. And as I indicated yesterday, as I'll say a little later, there are real difficulties, both of principle and practice, about coroners going into, in conclusions, the motivating factors that tip somebody over the edge, if I can put it in those terms. Finally, under the topic of general legal principles, may I turn to statutory review under Section 13 of the Coroners Act?
Yeah.
And I said earlier that its focus is different from judicial review. May I just make that good by reference to one case, which is Jones and Gwent Coroner, in the second authorities bundle at Divider 30, page 797.
tab?
33-0.
My 33.
Page 797.
Tab 3.
Oh, yeah, got it, yeah.
Concerned a boy who died after eating contaminated meat.
Yeah, I did, yeah.
The family sought a verdict for unlawful killing based on gross negligence of the butcher in complying with food hygiene requirements. The coroner rejected that argument, and then after the inquest, the CPS accepted that the butcher should have been charged, although prosecution was now impossible. The family brought a Section 13 claim with the attorney's fiat. The court held that the claim should fail because a new investigation wasn't required to uncover the truth. What was in truth being argued was a disagreement with the coroner's view about evidential sufficiency. But Lord Justice Elias made some valuable comments about the focus of a Section 13 claim at page 801, paragraph 12, first of all. Although he's speaking of error here, he refers to the kind of error being envisaged as one that casts doubt on the integrity of the proceedings themselves or raises concerns whether the verdict was reached on a proper consideration of all relevant evidence. And likewise,
Yeah, I'm just looking, let me just look, I do remember this case vividly because I was involved with the inquiry that had taken place. I'm just looking at what the coroner actually recorded at 5. Death was the result of an E. coli infection. Yes. Which had become contaminated with that organism. Because what had happened was the way the butcher ran his place, he was having cooked meat above uncooked meat, and there was contamination from the one source to the other, and then that was served or sold to the schools, and they were serving it to the children. So death was the result of an E. coli infection, probably due to the consumption of cooked meat, which had become contaminated with E. coli during the course of preparation due to a lack or disregard of good food. Okay, yeah.
now, in relation to that conclusion, the words due to a lack of or disregard for good food hygiene practices are probably too judgmental on straight Jameson principles.
Well, he was prosecuted for that, at least, I think, from recollection.
I'm not doubting that what he did was very bad.
Anyway, so that's what it was. So where were you taking us to
then paragraph 17 to 18,
yeah.
the submission is made that the test is whether justice has been done. And there's a citation from the case of ex parte Walton. And what Lord Justice Elias says in glossing that case and summarising the Section 13 jurisdiction at paragraph 18, letter C, is that the court was concerned with where something has gone wrong with the process, or for one reason or another, the coroner has not been in possession of all the material facts. I stress those passages simply to make good the proposition that the Section 13 claim is a rigorously practical exercise.
This wasn't a fresh evidence case, was it? Jones.
Well, it's not entirely clear whether it was suggested that the CPS's decision was relevant evidence. We would say that it wouldn't be, but the decision in the case is readily explicable because what was in truth being attempted was a judicial review out of time. As Lord Justice Elias separately said that the Section 13 process wasn't to be used for that purpose.
It was very difficult for the family. It looks like the family really were looking for. They wanted a forum in which to
articulate or air their grievances that this had been an unlawful killing. That's what this was really about, wasn't it? They felt that the butcher had acted so grossly negligently that he ought to be held to account for it.
That's the way the court saw the nub of their complaint. I think the submission was that they could, in light of the CPS decision, go into the facts further.
Yeah.
But yes, that was their objective.
Yeah. So it was sort of, so they must have been arguing something about insufficiency of inquiry first time round.
That was undoubtedly.
But as my lord says, it's not a case where there was a fresh piece of evidence.
Look, it wasn't focusing on fresh evidence. No. And finally, briefly, in relation to section 13, 2 points that we don't think are contentious. First of all, that insofar as the court is looking at decisions of the coroner, it adopts the same Wensbury standard of review as judicial review to any assessment of fact. That's the McDonnell case. It was contentious at first instance, but I don't think is now. Certainly, the court decided that point in favour of that contention. And secondly, and again I think it's common ground, while asserted Section 13 claim doesn't depend on a different verdict being probable, the likelihood or otherwise of a different conclusion is, as it was put in Mulholland, a matter of the first importance. May I then turn to ground 1 and begin by answering my lord's questions from yesterday, save my lord the trouble of shaking me by the throat on that matter at least. First of all, the question was which of Mr. Hyam's 3 suggested possible conclusions would be permissible. And the first conclusion, as I had it, was that the coroner could conclude that Jodie died by her own hand by taking an overdose of medication in her own home while intending to take her life. So essentially the conclusion which the coroner reached, but expressed by a suicide verdict in box 4, accompanied by those additional words in box 3, or perhaps a narrative in those words in box 4. So Jodie died by her own hand by taking an overdose of medication in her own home while intending to take her life. That would be undoubtedly acceptable as a conclusion limited to the means of death.
Yeah.
The second conclusion suggested was that the coroner might conclude that Jodie had taken her life following or as a result of a deterioration in her mental state triggered by the cessation of ESA benefits. Now, we would respectfully suggest that such a conclusion goes beyond the means of death in addressing issues of what underlying circumstances influenced Jodie's motivations and state of mind. So that's trigger wording or catalyst wording.
Isn't that just a finding of causation? I mean, I'm not suggesting that I'm not making any comment on the evidence, but just as an intellectual point, to say that X triggered Y, isn't that just a causation finding?
It is a causation finding. The question is whether it is within the rubric of the means of death. Many things can be, a death may be traced to many things which are not within the means of death.
And you say this is not within the means of death because the line is to be drawn not...
Because the means of death was Jodie taking her own life with the intention to do so, perhaps in the condition of medical condition she had, but question then whether she was motivated by one cause rather than another, and the extent to which they contributed, is not, we would suggest, naturally within the language of the means of death.
Aren't you being a bit narrow about it? Because I thought there was, we looked at case law yesterday that said the whole point of an inquest is to find such facts as may be material or may go to the public interest. So aren't you elevating what actually is coronial discretion about how far they ought to go? You're trying to elevate that and narrow it down into a principle of law to say they can't go there.
Well, I don't think I'm trying to do that. First of all, those passages, the duty of the coroner being to find such facts as are in the public interest, are of course subject to the statutory constraints. And I've shown my lords and my lady a series of cases about how the extent to which means circumscribes the exercise. And one can look at this by comparing the narrative suggested for the Hillsborough case in the Jameson decision, which was death due to crush after a gate had been opened, with the 25-page odd questionnaire which was produced at the end of the 2-year Middleton inquest, which traced the deaths to many causative factors, and one could say of many of them that's part of the cause, but it wasn't part of the means. It weren't part of the means. And that's the difference, I respectfully suggest.
So what does the means of death mean? It clearly, sorry.
What does the means mean?
I mean, it clearly means more than analysing the fact that this was a death through drugs, say, rather than some other thing, a blow to the head or something, if you fell over in your home. It's perfectly acceptable to say, well, the drugs entered the deceased body by her own hand. She took them. It would presumably be acceptable to say she took them because it was a mistake. She thought they were one tablet, but in fact it was another tablet. Then you wouldn't say suicide, because if you'd mixed your tablets up.
We have plainly as part of what the suicide conclusion is, the requirement of intent. So intent can be part of the
So intent can be,
means.
okay. But
what
the line is crossed when
underlay
you're
that
getting into trying to recreate the mental state of the person to see why did she intend to take her life that day. That is going beyond, you say, physical means.
based on the authorities to date.
Yeah.
Yes.
Okay. So the why goes beyond physical means.
Yes.
Yep. Yeah, thank you. Sorry, yes. So that was the second way. Sorry, you understand we've got to test you on
absolutely.
Yes, yes.
Absolutely.
Yeah.
Quite right, because these are important questions which, as I said yesterday, go well beyond the very primary coloured facts of this case. And then thirdly, Mr. Heim suggested that the coroner might conclude that Jodie had taken her life following or as a result of deterioration in her mental state contributed to, so not triggered by, but contributed to, by the cessation of ESA benefits. And it's the same submission that applies to that. But the real difference between Mr. Heim's second and third conclusions, trigger and contribution, is whether Dr. Turner's evidence might support them. Because Dr. Turner's evidence at the moment might be said to support contribution, but not trigger or catalyst.
Hmm.
So my Lord's second
You still
question,
say that, so you put B and C over the Rubicon, so to speak, in terms of where you say that.
as we understand it, and as I say, if the court holds otherwise, the coroner will be happy to hold an inquest as directed or with the scope that the court indicates.
The coroner's not arguing for any particular conclusion. She's trying to work out what you've got to do if we do send it back. And you say that on law present, even the questions of factual contribution to the state of mind leading to the decision to take your own life, the factual finding about the contribution is, at the moment, beyond what's gone before.
Factual finding about factors influencing the person, whether factor A motivated the person and to what extent it motivated the person as against factor B. Those sorts of considerations, would we say, go outside the rubric of the means of death as presently read by the courts, and would engage the coroner, moreover, in many cases, in a substantially difficult exercise.
That's a different point. The coroner doesn't have to do it. The coroner may say, I simply can't tell. The coroner may say it's not in the public interest to say the family are divided, this family isn't, but say the family were divided. So there are lots of reasons why the coroner may not do it. The question for us at the moment is, could she do it?
Well, it is questionable whether the coroner could exclude a conclusion on a fact if it's within the rubric and somebody argues that there's sufficient evidence and it's an important issue.
Sorry, just go over that again. I've missed
So
it.
if say, the argument were made that there is clearly sufficient evidence on the facts of this case, that some particular life event influenced the motivation, and the coroner can, as a matter of law, address that, it's difficult to see the coroner excluding that on the basis that she oughtn't to.
But not that you ought to. I mean, this is quite important. Say this goes back to the coroner, or say it's a similar case in a year or two's time, and different people are saying different things, or they're all saying the same thing. It was contributed to by this event. It was the fact that her husband treated her badly, the fact that the cessation business, whichever it is, it could be different facts. If the coroner is satisfied that she's done sufficient to record the factual means of death and doesn't go into that, will she have acted unlawfully? I can see that
No.
she can do it, but if she doesn't do it...
We would say no, but posit this situation. I'm sure Mr. Dixie and his clients wouldn't do this, but suppose the DWP turned up and said, if you're going to make any determination about the effect of the benefits decision, you must also look at the events going on in Jodie's life in relation to her children and in relation to her chronic pain and the extent to which they contributed, and you must seek to unpick those as well. The coroner probably couldn't say, I'm not going to look at those or make conclusions upon them because it would be unappealing for me to do so.
But can she not say there are different views by different participants as to how far back I have to go? I'm going to go back as far as saying this was suicide, but in the circumstances of this case, I don't think it's in the public interest to go further back and to consider the factual contribution of different factors. Could she lawfully do that? Because I'd rather assume that if Mrs. Dove succeeded, it would go back to the coroner and she could decide that she accepted or didn't accept Dr. Turner's evidence, or she could still decide that it was not necessary in the interest of justice, whatever test she uses, to make a finding on that. She might say, yeah, well, I've heard what you say about Dr. Turner. I have no reason to doubt Dr. Turner. I think this is enough. Could she not do that?
Well, there is a difficulty about a coroner saying, I have looked into something, a conclusion is possible, is evidentially possible, is sufficient evidence, but I'm not going to consider it because it's not in the public interest for me to reach a finding on that point. Because as Lord Brown said in Hurston, has been said in a number of other cases, while the scope of inquiry is a matter for the coroner's judgment, the verdict and the conclusions are subject to rules of law, which require the coroner to reach conclusions on matters for which there is sufficient evidence which fall within the means of death.
She's got to decide cause of death, the medical cause of death, and the conclusion. Here's a short form. So we accept she's got to do that. And if she said, I'm not dealing with this, it's too troublesome, then she'd be acting unlawfully. But if she says, I found the medical cause of death, I found that it was suicide, I'm satisfied that this person decided to take his or her own life. There are issues as to what contributed to the mental state leading up to that life. I do not think it's necessary for me in this case to adjudicate on that. Would that be lawful?
The coroner would have to have a reason for considering that to be the right course, because not adjudicating on something which is within the means of death, the coroner would have to have a reason for not doing that.
But we've worked out, haven't we, what the means, what the narrow approach to means of death is. I mean, let's just take a case like this where sadly, it looks like suicide was the short form verdict. And then we accept, don't we, that coroners have a wide discretion about what happens after that. And the Chief Coroner's own guidance says that they can attach a narrative to a suicide short form, where you can box for, look how it wants. And I suppose I echo my Lord's concern that what we're doing is clipping the wings of a coroner to decide what they want to do with their inquest. And so I come back to my point that we're elevating, aren't we, to an issue of to a legal proposition, something that properly lies actually within the case management discretion of a coroner. So a coroner might say in a case like this, where it doesn't look like there's going to be any real dispute at the moment about contributing factors. The coroner might say, I think it is in the interest of justice in this sort of case, given public concern or whatever, to take a look behind the curtain and look at what lies behind. That doesn't read across necessarily to another case where you've got a family fighting about why somebody committed suicide and you've got multiple factors, where a coroner could quite legitimately say it's just not in the interest of justice for me to travel into these areas. I'm not going to be in a position to make findings.
So certainly we would accept that the coroner has very, very broad discretion on the scope that the inquest can follow. What I was addressing, I hope by reference to the authorities, the applicable authorities, was whether the coroner could address motivations in a conclusion limited in the Jameson sense, and then as a result of that, whether an inquest to look as far as this one might would be a justifiable proposition.
And I think where we've got to on that is that you can't, I think what your proposition is that there's no other case in the senior courts. We've seen some coroners who've done riders to suicide verdicts, but there's no adjudicated case in the High Court or above where you've had this sort of rider that's been given a tick. But you can't point us to a case where a senior court has said it mustn't happen.
No. We have to work from first principles about whether motivations of this kind and comments on the underlying cause are within the means of death.
Yeah.
My Lord's second question.
That's very helpful. Thank you very, very much. That is helpful. Yeah.
Not at all. My Lord's second question was whether the evidence could support any of those conclusions, supposing them to be legally permissible. As to the first one, effectively the conclusion the coroner did reach, but perhaps with an additional short narrative, the evidence could plainly support it. As to the second, trigger or catalyst wording, we'd suggest, and I'll address this briefly later, it's difficult to imagine the evidence supporting trigger or catalyst wording, given the range of stressors bearing on Jodie at the time of her death. And it is legitimate for the court to look at that issue. It's not a question of prejudgment, because that's what a Section 13 application involves. And as to the third, so contribution...
Well, the other stresses and the wording of the report itself, actually, I
yes.
think. Yeah.
Yes.
Is what you would say. Yeah.
Well, the careful way that the questions were asked and answered.
Yeah.
As to the third, contribution wording, we'd accept that the evidence does suggest that the cessation of benefits contributed to Jodie's desperate state. But we would say that the evidence before the coroner at the first inquest was to that effect, didn't have a psychiatrist's endorsement. It was to that effect from Mrs. Dove, endorsed by the notes made by Jodie. Coroner didn't include it in her verdict, but that was because of her understanding of the limits of the inquiry and verdict.
Do you say that, or was that just because of, to put Mr. Hyam's point to you, that was because of the quality of the evidence, and he encapsulated, I think, by talking about Dr. Turner being objective evidence. It's a different type of evidence, but it would be difficult for a coroner to reach a conclusion of causation with the best will in the world based on family views about how something came to pass.
Well, I very respectfully take issue with that. If a coroner, as this coroner did, heard Joy Dove's evidence, as this coroner did, and she indicated pretty clearly in the course of the inquest that she accepted that evidence and that she was going to include it in her sentence.
Except that's what the mother thought.
Yes.
There's a world of difference between accepting that you believe your statement to be true and you're giving me true evidence, and accepting the content of what is said.
If a coroner could legitimately include such contribution wording in a verdict, then a coroner could legitimately do so, having heard a deceased person's mother say she got this note and it sent her into a desperate condition after which she...
I see that. I do see that on Mrs. Dove's evidence alone. She was there, she knew her daughter, she was with her right up until the end, and she can say, this is what my daughter was telling me. It was playing on her mind. She didn't know how she was going to manage with her benefits cut off, and it blotted everything else out. That would be her evidence as to what her daughter said, and then you could infer things from her daughter's state of mind from what she said. But the Turner evidence, without meaning any disrespect to Mrs. Dove, is different. This is a chap who's a psychiatrist, and he knows a lot about the way mental state works. And he says, yeah, don't forget, this is a woman who's got an underlying emotional unstable personality disorder diagnosis, and she's got chronic pain. And when you've got those medical factors, something like the withdrawal of benefits that one person might be able, in inverted commas, to cope with, would be an enormous hurdle for somebody in that position to cope with. So without wanting to downplay what Mrs. Dove said, Dr. Turner had different and additional evidence from what Mrs. Dove had, because he knew about the workings of the mind from the point of view of psychiatrists.
Well, I entirely accept Dr. Turner's evidence buttresses Mrs. Dove's, but the coroner had before her the evidence of Jodie's medical background and her mental state, including the UPD, the previous overdoses, and all the GP's full account of the different meetings in the chronology. And with respect, it would not have been difficult for the coroner to say, as a matter of common sense, that somebody with those conditions, when confronted with the prospect of having all means of support cut off, that could and would be expected to exacerbate their mental condition. And that's what Mr. Hyam takes from it, a deterioration in mental state. That, with respect to Dr. Turner, who was himself relying on general propositions, could have been derived by a coroner from the factual evidence. And if this kind of conclusion can appear in a verdict, then this coroner could have, we would suggest, included it on the basis of the evidence she had.
I'll have to reread the transcript, because she says at least twice, if not three times, what the family believe. Yeah. Anyway, I understand that.
She also, I think, says somewhere that she says that lies outside the scope of her inquest.
She says investigating the DWP process, I think she says, is outside her remit.
But you might take from that she thought that... I thought her wording of her summing up to herself was very notable and clear, that she said, I'm recording Mrs. Dove's view, and there seems to be a sense of, and I accept that is her view, I accept that it's a truthful view that's offered to me, but that I can't go any further than just to record that.
So the question is, first of all, whether another coroner, armed simply with the views of Dr. Turner, and assuming for good reasons that he couldn't go a lot further, would legitimately be able to go further in terms of inquiry, and secondly, would be able to legitimately to go further in terms of conclusion, and whether that justifies...
On the hypothesis that it goes to another coroner, it would necessarily follow that as a court we thought that it was at least open to that coroner. So the jurisdictional issue would have disappeared. It would have become just an evaluative one of what was the right thing to do in the circs.
Yes, I'm not raising a jurisdiction.
No, but I think this coroner did think there was a jurisdictional block.
Well, I think the way she put it was that the passing comment on the DWP process was outside the remit, because she was asked. The suggestion was that she'd go into that decision making.
Well, I think they got merged. I mean, I'm looking at it. Firstly, you're quite right to say, and the coroner does record at page 314 of the court bundle, to record Jodie's previous medical history, which included the chronic back pain, and the mental health issues and the earlier documented overdoses. And then she does record what her mother and indeed Jodie's sister, not just Mrs. Dove, it's the sister as well, who said that at the hearing. But if you look at 310, her sister's just given evidence about what she thought the funds was. And the coroner says, I said when Joy you spoke, I'll make a note when I do my deliberations about the stress factor and the ESA claim. But as I explained at the outset, you know as a coroner and the inquest, it's not our position to question decisions made by the Department of Work and Pensions. That's just outside the remit of this court. I'm not criticising the coroner, and for a long time, the way in which the case has been put by the other side, if you like, is that they want to show that in some way this was down to the DWP. And now that's dealt with by the ICE inquiry. They've said what they've said about the failings, and it's a situation where the mental health state and were the failings reprehensible failings have been decoupled. And the question is, in trying to understand why, you'll say I shouldn't have used the word why, but in understanding the physical means of Jodie's death, could a coroner now decouple mental health state and say, yeah, this was a complex case. Jodie had a lot of stress factors, chronic back pain, mental health, the family factors, but then there was the cessation of benefits that itself worsened things, and her reaction to the benefit withdrawal was itself partly magnified or heightened by the health problems.
Well, in my submission, on a fair reading of the transcript, the coroner was not excluding consideration or in the course of the evidence of Jodie's mental state, or indeed.
So she wasn't excluding it, she just said she wasn't going to go there in the exercise of her discretion.
But she wasn't going to go into the decisions made, whether they were right or wrong.
Mm.
In that regard, she was, in our submission, right, and that appears to be common ground.
Yeah.
That's why she says it's not our position to question any decisions made by the DWP. That's just outside the remit of the court. Indeed, she doesn't stop any of the witnesses talking about the effect of those decisions on Jodie. That is covered in the evidence. It's not covered with the assistance of a psychiatrist saying a person with EUPD faced with this sort of decision would be expected to suffer a deterioration in mental state. Yeah. But again, with respect, it may not require a psychiatrist to say that.
You used the word common sense about 10 minutes ago. If you'll forgive my saying so, that isn't, to me at least, a hugely attractive proposition. I mean, let's take for the sake of example a criminal trial, and mum and dad come along and say, I'm quite sure that this happened because the husband was beating her over the head all the time with a stick. The judge would have to say, well, that's what they think, but we have no evidence that that's correct. They simply don't have the expertise. But if a psychiatrist came along and said it, well, that would be for the jury to consider. The judge would be quite wrong to say to the jury, well, it's common sense, isn't it?
Well, I take that point. There is a distinction between the criminal trial context and this context.
Well, I understand that, but I'm simply pointing out, I mean, coronial proceedings do operate under some broad legal principles.
Okay.
And there is at least some passing acquaintance with issues of admissibility and relevance and probative value.
Well, the rules of criminal and civil evidence don't apply in inquests, but I entirely take the point that the coroner would be careful not to reach conclusions which weren't properly evidenced, although they would be conclusions on the civil standard. But the point is that in most inquests, including inquests into death by suicide, there isn't an independent psychiatrist expressing views. Coroners do typically have to do their best in reaching conclusions, including as to suicidal intent.
Suicidal intent, yes. And you've got the notes, what Jodie wrote. You've got the physical circumstances. Jodie was back in the flat. She'd gone into the flat and locked the door. There's nobody else present. And you've got inferences you can draw from the fact that it was the medication that she had, and it was those three medications that were the cause, the medical cause. So you've got a lot of things that tells you, was this a person who took her life by her own hand, or was it murder, putting it dramatically. So you've got all of that. This is a more nuanced thing, and the oddity about this case in an odd sort of way is that the family clearly thought that a major feature in the mental presentation up to death was the withdrawal of benefits. They were not happy about the way that the DWP dealt with it afterwards. When it's looked into, there were in fact multiple failings by the DWP, which many people, and I'm not going to express a view, would think were reprehensible on the part of the DWP. But that, oddly, is not now the thing that's going to trigger the new inquiry. But in the course of that, because they've got the ICE report and they've got Dr. Turner's report, there is something that, with all due respect to Mrs. Dove and the family, is significantly different, because you've actually got in this case a psychiatrist who says, well, I know about personality problems and I know how they work, and I know how that will affect people who have their benefits withdrawn, and I can see that it could be a factor that's linked to the death. And the question is, in that unusual set of circumstances, if it were possible for the jury, for a coroner to consider a degree of causation, would it be desirable at least to give the coroner, if you like, the opportunity to see now whether or not that is something she considers necessary and appropriate? She may not consider it necessary and appropriate, but I wonder whether the opportunity, given that there's been this other set of evidence, Dr. Turner.
Well, I don't want to go too far, given the position.
No, because it may go back to the coroner. I understand, so I'm pressing you, and yes, you're trying to be neutral, and you're trying to help, and no matter how much you help, we come back and want more.
But all I would say in relation to Lord Justice Davis's point is that coroners do often have to decide questions of motivation and also psychiatric intent, including in nuanced cases, without always having the benefit of psychiatric.
Yes, because you may have to draw inferences from what the person has said and done. Yeah.
But I certainly accept in the criminal context and perhaps in some coronial context that psychiatric evidence is valuable.
Yeah.
So just before we leave that point, can I, and this may not add very much, but what has been in my mind, given this is a fresh evidence application, is to ask how the inquest would have unfolded if the ICE report and Turner had been available first time round. So if we could just sort of pursue that hypothesis a little bit. I think you probably say that the coroner would have engaged with Dr. Turner. You wouldn't have had an inquest form quite like this. It wouldn't have read quite. She wouldn't have just said Dr. Turner says this in the same way she says mother says this.
No.
There would have been. She would have been invited to make a finding, wouldn't she?
Well, first of all,
would have said yes or no.
The coroner would have received Mrs. Dove's evidence, as she did after the GP's evidence and so on. She'd then hear from Dr. Turner or another psychiatrist, essentially asking the questions at 1980D in the report, and then the coroner, insofar as it was necessary to establish the chronology, would admit elements from the factual section of the ICE report to the extent they hadn't already been covered by Mrs. Dove, informed by that report. Better evidence may have been directly from Mrs. Dove. And then the coroner would be addressed on conclusions and would reach conclusions based on whatever principles my lords and my lady find.
So would have been invited to draw the inference from Dr. Turner, and I'm assuming a lot, because of course I'm assuming that there would have been representatives and funding and all sorts of things that may not have happened and didn't happen first time round. But I've got myself to a place where I think that the overwhelming likelihood is that in that hypothetical scenario, the coroner would have decided whether or not to make a finding of causation, because she would have had Dr. Turner and might have said, actually, I'm not going to go there. It's just, it's not my business or whatever. Or would have said, yeah, in the particular circumstances of this case, I am prepared to draw that inference. So you would have had that.
Yes, the DWP may have argued, or would have been able to argue, first of all, not within the scope of means. Secondly, it's not a conclusion that ought properly to be expressed in a conclusion for the reasons that we've explored. And thirdly, not sufficient evidence to disentangle it from the other stressors and single it out.
I mean, because if Dr. Turner gave evidence, the coroner might ask two questions. Doctor, did this trigger it? And he might say, I can't go that far, I'm a doctor. I can't say what was the final trigger. Can you say it altered her mental state? Oh yes, I can say that. And she might have that, and then she might have to decide what to do about it. But that's really the ground that we've covered, actually. Yeah.
True, but I think it's difficult for the claimant, having limited the evidence by questions, to Dr. Turner going as far as he did, to say, well, he might, who knows, go even further.
But on one reading of the Turners we went through yesterday, may not be saying the death was caused by, in the sense that this is what led her to kill herself. But there might be, I mean, there's a lot going on in Jodie's life. There's the chronic back pain, there's the mental health, there's the family things, and then there's the cessation of benefits. So he might have meant that when he did his report. Anyway, but that's ground that we've covered, so we mustn't,
Yes.
rather than asking you unfair questions, keep asking you the same unfair questions.
No,
That's double unpleasant.
Happy-
Anyway, is that what you want to say on ground one?
Happy to help. May I just very briefly address the three lines of attack, just against the context of what I've said.
Yep.
The first line of attack is that the Divisional Court worked on the basis that the coroner was looking for a second inquest to investigate the DWP's decision. We say the Divisional Court proceeded as it did because of the way that the case was argued. But the point has also been made that the court should order a fresh inquest so that it can rely on the conclusions of the ICE report. That's paragraph 13 of the appellant skeleton. My lords and my lady have my points on that, namely that a Jameson inquest couldn't receive evidence of the critical conclusions in the ICE report, that a Jameson inquest couldn't say anything critical of the DWP, and the analogy with the Norfolk case, where the AAIB report was squarely focused on how the accident happened, is not a correct one. Second line of attack is that Dr. Turner's report justified a further inquest, and the Divisional Court there considered, and this court has to consider with respect, whether it would have been realistic to expect Dr. Turner to go any further in an inquest hearing than he went in his written report, and whether that makes a difference. All we would say is that it would have been an invidious and at least highly difficult exercise for the coroner to reach more definitive conclusions than Dr. Turner has done in his report. First of all, because of Jodie previously linking her suicidal mindset primarily to chronic pain. That's pages 26 and 270 of the supplementary bundle. And because in the weeks before her death, she had these family events. I'm not going to go into
the details.
Page 270. Equally, the notes made by Jodie contained references to a range of those stressors, as my lords and my lady know. And of course, the benefits decision was being reviewed at the time of death, so it wasn't an irreversible decision. Whether Jodie saw it as such, we may not know. The third line of attack is that a different conclusion may be returned. I've largely addressed that. I would just make a few supplementary points. First of all, the conclusion of death by suicide is undoubtedly correct, and coroners are urged to use short-form conclusions wherever possible, with or without a narrative. That's the guidance, Chief Coroner, tab 46, page 1208. And the question, therefore, is whether the prospect of a materially different conclusion justifies going through a second inquest. In that regard, may I briefly take my lords and my lady to one final authority on ground one. It's Divider 32. It's a case called McDonnell. Yep. It's a case about a fatal cardiac arrhythmia where there were complex questions about the contribution of multiple prescription medications to the vasovagal event which led to death. In short, the court concluded that while the verdict could and perhaps should have been supplemented by reference to the fact that the combination of some medications prescribed was contraindicated, that didn't justify a new inquest on the Section 13 test. And the critical reasoning is from paragraph 41 on page 830. Judgment of Lord Justice Beatson.
Which paragraph?
Paragraph 41 on page 830.
Paragraph beginning, Mr. Huff, QC.
Somebody or other on behalf
Here
of
he
the
is
coroner.
again.
It's in dreadful submission.
Yeah.
Accepted.
There's something on the combination of drugs. And this could have been. Oh, yes, okay.
Lord Justice Beatson said that in such an inquest, the determination must be limited to the means of death. In comment on other matters, it is prohibited. He also referred to a comment by Mr. Justice Males that a simple reference to the combination of prescriptions might have been misleading. He then goes on to say that at paragraph 42 was the contraindication of the medications not to be within the rubric of the Jameson verdict, including a narrative verdict. And he refers to his own judgment over the page in the Butler case.
Can I just check on the facts? Was the combination of drugs, I understand it may or may not have been an appropriate thing to have prescribed for this person, but was the combination of drugs something that bore on the death? And I use the word bore on to be neutral, or was it not?
The combination of drugs was a factor in the death. We can see that from the head note about halfway down the page. The coroner's decision was that deceased died due to fatal arrhythmia triggered by a vasovagal event in the presence of excessive codeine and the drugs citalopram, amitriptyline, and quinine.
Okay.
So the combination of such drugs.
It was related to the means of death, and therefore you'd have the same arguments here about how much, so on, and you say 41 to 42 shows that kind of attribution is often misleading.
Yes.
So this was a classic clinical negligence case, wasn't it?
It was.
Yeah.
It was.
And what the coroner said, I'll make a comment about codeine, but I'm really not going to dig any deeper than that.
The coroner did not. Part of the argument for the Section 13 claim was, in a new inquest, a conclusion could be reached to the effect that the combination of drugs was contraindicated. That would inform the public and would properly form part of the rubric of the verdict.
And wasn't fresh evidence, what was it that triggered the Section 13 application in the field of the Attorney General? Insufficient inquiry rather than new evidence, was it?
It was primarily insufficient inquiry, but
because the bit I'm reading from, if I don't know this case, you do obviously rather better than I do, but the coroner had made a sort of halfway house conclusion. It looks like there'd been an excessive quantity of codeine. I'm in the head note, and that
Yes.
played a material role, and the coroner had therefore given death by misadventure.
Yes.
So I imagine there were other verdicts that were natural causes was probably also one of the runners, wasn't it? And the family thought that was a rather
It would have been one of the runners. Mixed drug toxicity was the conclusion of the post-mortem.
Yeah.
It was primarily about insufficiency of inquiry. I can't remember, counsel will recall, but counsel can't recall whether there was any fresh evidence point.
No, it doesn't. It doesn't look like. It looks like this was.
Yes.
I mean, there are quite a lot of these sorts of cases where the evidence is pretty complicated, and the coroner just goes, "That's not what I do. It's not what I'm here for."
Yes.
And if you look at 826, paragraphs 20 and 21, we have the section 2 of the record giving the cause of death, and the medical cause of death was fatal arrhythmia in the presence of those drugs. And then the deceased did deal with, he collapsed at his home in the morning, he'd had a higher dose of codeine than prescribed, then dealt with what he'd eaten and drunk. He had a long history of mental health problems, dependence on alcohol and benzodiazepine, and chronic pain, for which he was prescribed that. So all they did was not say whether the prescription was appropriate, and that seems to be what they're asking for.
Yes, there wasn't in this case an issue about whether the conclusion could have gone on to talk about the motivations.
No, because it wasn't. There's no evidence that the deceased intended to harm himself.
Absolutely, but of course, motivation could come into misadventure as well as
yes.
suicide. Since misadventure requires a deliberate act.
Yep.
So that's what we say on ground one, stressing, please, that the coroner is not seeking to urge a particular conclusion, but to express some views on the law which may or may not assist the court. Ground two, new evidence and Middleton inquest. And the argument here is that on the basis of the fresh evidence, there is a justification for a new inquest, which would be a Middleton inquest, the argument being that the Article 2 procedural obligation was engaged on the basis of arguable breach of the operational duty. The general duty was addressed below, but is not addressed here. May I look briefly at some authorities governing the principles, then turn to the Divisional Court judgment and the appellant's arguments, and I shall do this as briefly as I can. I'm going to look at three authorities, Morahan, Mitchell and Ray Bone. Morahan in this court, at authorities 44, page 1177, is the most recent case in this court to consider the Article 2.
Where we get Morahan?
Morahan, in the Court of Appeal.
Could you just give me the reference again?
Divider 44,
Thank you.
1177.
Thanks so much.
This was a case where a voluntary psychiatric patient had died in her own home after an accidental overdose of recreational drugs while absent from the hospital without agreement. And it was suggested it was an Article 2 case because the hospital shouldn't have let her go or should have taken further steps to bring her back. Argued that an Article 2 operational duty arose either because the substantive operational duty, it was argued that the procedural obligation arose either because the operational duty was arguably breached or because of an automatic engagement. And both arguments failed. The case also decided that a real and immediate risk of death foreseeable to the relevant authorities is a requirement of the duty arising, the operational duty arising, not merely its breach. And from paragraph 12 on page 1180, Lord Burnett summarised the Article 2 operational duty and its development in the cases, starting with the Osman and the articulation of the test, and then 1181, reference to Savage and Ray Bone, extension of the duty into protection of patients, psychiatric patients from suicide risks. And in paragraph 15, he says, the operational duty is to protect against particular risks of life, not all risks. That's clear from Osman itself. The only risk in question was the risk of a criminal attack by a third party, also clear from Ray Bone. In that case, the operational duty existed to protect Miss Ray Bone from the risk of suicide. So those are the risks particularly related to the safeguarding responsibilities assumed by the state agencies. If we move on to 1188, paragraph 46, Lord Burnett says, there is no authority which decides that an Article 2 operational duty is owed to voluntary psychiatric patients and protect them from all risks of death. Risk of death in this sad case is accidental death from the recreational use of drugs of a voluntary patient, genuine liberty to come and go, far removed from the circumstances in Raybone where the very purpose of being in hospital was to protect against the risk of suicide. And then there's reference to the Ulla principle in its expression in AB, before Lord Burnett says at paragraph 48 that the appellant's case entails an invitation to march ahead of Strasbourg in this area which the court is bound to decline. A similar approach, of course, as we've seen, was taken in the Gardner case in relation to Ovid and Kent. The next case, the second of three cases I'd like to show, and also my lady, is the Mitchell case. Divided in 19, first authorities emerging will be familiar. This was an attempt to extend the Osborne Article 2 operational duty from police to a housing authority, which had been informed of repeated threats to kill made by one tenant against a neighbouring tenant. It was the Scottish equivalent of a strikeout or summary judgment procedure. The House of Lords held that the claim couldn't be maintained. All members of the court dealt with real and immediate risk. But Lord Roger, with whom Lord Brown and Baroness Hale agreed, made clear that no such duty was owed as a matter of law and responsibility. He made that point at paragraph 64 on page 441. In the expected way, he deals with the development of the operational duty from Osman, paragraph 65, for recognising that the duty goes further, where a state has assumed responsibility for an individual, whether by taking him into custody, imprisoning him, detaining him under mental health legislation, or conscripting him. And then over the page to 66, he adds that Article 2 duties are of wider scope, giving some examples of situations before saying that public authorities under general duties may come under a distinct operational duty. Paragraph 67, he says that there is an issue over real and immediate risk. And then at the end of 67, he says, but even leaving that matter to one side, in my view, the pursuer's Article 2 case is fundamentally irrelevant. Or Scott's legal argot for demurrable. He then says, at paragraph 68, that the police force in the area has the responsibility to protect people such as Mr. Mitchell from criminal violence. And at 69, the position of the local authority is quite different. If the local authority had allowed their housing stock to fall into disrepair, so that tenants were at risk of suffering life-threatening injuries or becoming seriously ill, the local authority would have been in breach. At letter H, Mr. Mitchell wasn't in the custody or control of the local authority, wasn't ill or otherwise in need of care because of old age, wasn't living in local authority sheltered accommodation, hadn't been deprived of his freedom of movement or action, nor otherwise assumption of responsibility for his safety. Over the page at 443, I see nothing in the relationship of landlord to secure tenant to give rise to any positive Article 2 obligation.
Where's that?
This is 443 by letter B. So the analogy here is benefits agency has the responsibility to prevent people falling into destitution, Whaler, MSS, GS, and so on. But it would be a significant extension of the authorities to recognise a duty to safeguard mental health and prevent suicide and self-harm risks.
Well, actually, rather than say benefits, the DWP have responsibility to stop people falling into destitution. What the DWP actually has responsibility for is administering the system of benefits laid down by Parliament to determine who should get benefits in what circumstances and how much.
Yes. 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 My Lord's right to elaborate on that way. Yes. And the final authority on this subject, Ray Bone, divider 25. I'm not going to go through it fully because I know that it's an authority very etched on my Lord's and my Lady's mind. Lord Dyson began his discussion at page 642, discussing the Osborne case and its development. You just observe at paragraph 16 that he describes Honour Yildiz and Mamadov, prefaces the discussion of Honour Yildiz and Mamadov by saying that these are cases where the duty has been found to be owed for what may be described as dangers for which in some way the state is responsible. So setting up a dangerous refuse tip or organising a police operation which causes somebody to immolate themselves. Then we have the indicia beginning from paragraph 21, page 644, where Lord Dyson says that existence of a foreseeable real and immediate risk is a necessary but not sufficient condition for the duty to arise. He looks for further indicia. First is assumption of responsibility, including by the exercise of control, and the examples given are cases where the state has taken a wraparound responsibility, if I can put it that way, for somebody's life, and has taken in particular responsibility for safeguarding the person from the particular risks which are the subject of the proposed duty. So that's what we say about the assumption of responsibility, indicium. Paragraph 23, he deals with vulnerability. And as my learned friend fairly accepted yesterday, the example he gave was protection of a child at risk of abuse, a situation of helpless vulnerability, where the Strasbourg Court had found special considerations to apply. And then, thirdly, paragraph 24, nature of the risk. Is it an ordinary risk, the kind that individuals in the relevant category should reasonably be expected to take? And in our submission, the reason Lord Dyson refers to that point is explained by his example case of Stoyanovi. Because in some cases, people such as soldiers may be expected to run serious risks in the ordinary course of their lives. And it may explain the imposition of a duty that wouldn't otherwise exist, that the risk is particularly unusual on these facts. Now, from these authorities, we say three basic propositions can be drawn of relevance here. First of all, the hallmark of cases where an Article 2 operational duty has been recognised is where a state agency has a particular responsibility for safeguarding an individual or group against a particular type of harm. Article 2 duties are not to protect an individual against all risks, but against those risks for which the state agency has a particular responsibility to safeguard the person.
So I've written down particular 3 times. Particular responsibility.
Particular responsibility.
Safeguarding a particular group against particular harm.
Risks.
Right.
I think you only need the second two, actually. You have responsibility to safeguard particular individuals or groups against particular types of harm, yes.
Apologies for complexity.
Don't worry.
Secondly, where an issue arises whether an Article 2 operational duty should be recognised in a new situation, the court naturally considers the re bone indicia as relevant considerations, but not as a sure guide, but also takes account of the ULA and AB principle that the court shouldn't overreach clear and constant jurisprudence of the Strasbourg Court. And thirdly, so far, Article 2 duties to protect individuals from suicide have in general been found to exist only where the individual is in a community controlled by the state in which such risks are particularly present, such as a prison, psychiatric hospital, or conscript camp, because of the responsibilities that exist in those environments, the risks which are inherent there. Now, against those backgrounds, let me address the appellant's arguments. Again, I hope succinctly. First of all, this is paragraph 32 of the appellant's skeleton. She argues that the Divisional Court failed properly to consider the context where the issue was whether there was an arguable case of breach of an Article 2 operational duty. As I've said, it is common ground that the obligation is engaged where there is an arguable case on the evidence. However, the question whether an Article 2 duty is owed in a given situation is in general an issue of law with a right or wrong answer. That's how it was treated in Mitchell, Raybone, Morahan, also in Gardner, Davison and Maguire. And the importance of the arguability threshold is primarily in relation to the question whether an Article 2 duty, which can be owed as a matter of law, has arguably been breached, so real and immediate risk, and whether proper measures have been taken which could reasonably be expected to avert the risk. So in our submission, the Divisional Court didn't approach the matter in the wrong way. Secondly, this is paragraph 35 of the appellant's skeleton. The appellant cites a line of authority to the effect that the state may violate Article 3 rights if it denies a person shelter, food, other basic necessities of human life. I don't take my lords and my lady to the cases because I know they're familiar to the court, but references, Limbuela, Divider 13, page 216, page 222, Lord Bingham's focus is on whether the state has imposed inhuman and degrading treatment which deliberately deprives the individual of the most basic needs of human life. In our submission, the same approach is taken in the Strasbourg cases, notably the Grand Chamber case of MSS. Its authorities 22, page 485, where at 534, paragraphs 253 to 254, the court said that Article 3 duties may be engaged where an applicant dependent on state support was left in a state of serious deprivation or want. In our submission, those propositions are perfectly reconcilable with the Article 2 authorities which we've been considering because of the particular responsibilities of the state benefit agencies. Thirdly, from paragraph 37, the appellant argues that the Divisional Court wrongly applied the Raybone indicia. And as to assumption of responsibility, the argument is that the DWP assumed responsibility for Jodie's welfare and safety by providing her with benefits and subjecting her to a regime of assessments. But as we read the authorities, the question is whether the DWP assumed a responsibility for safeguarding her against the type of harm in question, namely self-harm and suicide risks. The fact that they had procedures for dealing with vulnerable people doesn't establish the existence of such a responsibility.
Hold on a second. The fact they have procedures for protecting vulnerable people doesn't mean
there is such a responsibility. The wouldn't have made a difference in the Mitchell case if the local authority had had procedures for dealing with reports of violent tenants. In fact, it would be surprising if they didn't have such procedures.
The fact that they got procedures protecting vulnerable people doesn't mean that they've assumed responsibility for safeguarding them from the risk of suicide.
Exactly.
Right, yeah.
And it would be a significant expansion of Article 2 duties to find that a state agency providing economic benefits to individuals who may be vulnerable thus comes under duties to protect them against mental distress leading to self-harm of decisions and the way that they are made. In our submission, none of the three cases cited by the appellant in paragraph 39B of the skeleton, which addresses this point, is comparable. You don't need to go to them, but because they're familiar, and my lords and my lady saw them yesterday. There's the Watts case, elderly person transferred from a care home in such a way as to reduce her life expectancy. Clear responsibility of the state for that person's care and life. That person being under the constant control of the state and physically moved from one place to another, which would, it was said, although not accepted, would foreseeably shorten life expectancy. Kemaloglu, a young boy under the care of the school, sent home in a snowstorm without the precaution being taken of the bus company being told. Again, full responsibility for the boy's safety. Thirdly, Mammadov and Azerbaijan. The court here said that it was necessary to consider the nature of the police operation and the degree of control that the authorities exercised over the events. That's paragraph 106 of the judgment. And with that preface, the court then frames the duty, as my lords and my ladies saw yesterday, very carefully, in limited terms, that where an individual threatens their life in plain view of state agents, where the threat is in relation to the actions or demands of the state agents, then the duty may arise. It was a very limited development of the duty, and it was explained by Lord Dyson and Ray Bone as a situation of the state creating a danger right in front of them, as well as having 25 to 30 police officers literally in control of events. Vulnerability, it's not in doubt that Jodie suffered from a condition which put her at risk of self-harm. In that sense, she was vulnerable. But the individuals in the cases of Morrison, Davison and Gardner were all physically or psychologically vulnerable to the risks which formed the basis of their claims. The recognition of an Article 2 duty based solely on vulnerability without a thoroughgoing assumption of responsibility has been found only in the very limited context of child protection. And then nature of risk. The argument here is that the appellant that Jodie faced a risk which was unusually high among ESA claimants. In our submission, that Lord Dyson was referring to the nature of risk for a very particular purpose, which I've identified, namely to explain why some who might be expected to run risks shouldn't run them in a particular context. And in our submission, it doesn't justify the significant extension of an administrative agency assuming mental health safeguarding responsibilities. So that is a whistle-stop tour of our responses to those. Before I conclude, let me address one point my Lord raised yesterday, which is if the Article 2 obligation were engaged, procedural obligation were engaged, would the ICE investigation and the existing inquest be sufficient to discharge it? I won't go far into this question because the coroner didn't consider it, because because she didn't think the issue arose. But to assist the court, we would just say this. The issue at that stage would be whether the convention's standards, adumbrated in the mean, would be satisfied by the collective effects of the ICE procedure and a Jameson inquest. And recent cases such as Grice decided by Mr. Justice Garner looked at how a collective set of state procedures can discharge the Article 2 obligation, in that case, criminal trial and domestic homicide review and so on. As to independence, as we understand it, the ICE process does have structural independence so far as the requirement for independence from those who exercise the decisions in dispute. We of course accept that independence is a quality that can have degrees. As to family participation, that participation in the ICE process was plainly limited, but the same is true of a criminal trial, which can, alongside a Jameson inquest, discharge the Article 2 obligation.
And in fact, the family couldn't have known about what they should have done and failed to do. Mrs. Dove knew about the way they were behaving afterwards, but it was only when somebody looked into it that they found out what went on before. Mrs. Dove, nobody could have known that they were failing to comply with their policies.
Yes. Well, I don't want to push the point too far.
Yeah.
I'm simply drawing points to the court's attention. Yeah. But as I say, it would be wrong for me to go further, given that the coroner didn't even address that question in her own mind. So, my lords, my lady, those are our submissions. That question is whether the Divisional Court was wrong to hold it's not in the interests of justice for there to be another inquest. May I say again that this is undoubtedly a most tragic case, and that the ICE investigation exposed serious and indefensible flaws. May I also say again, the court will abide by not only any decision of this court, but also any guidance this court gives.
Well, thank you very, very much, Mr. Hunt. You've been very helpful and very patient with us as we've asked you lots of questions. Thank you very much indeed.
Patience has been mutual. Thank you.
Right, so it's Mr. Dixie.
My lords, my lady, may it please the court, my submissions will be focused on the second of the grounds before the court, namely that the Divisional Court was wrong to conclude that Miss Whiting's case didn't give rise to an argument reaching Article 2, and so a fresh bottom inquest is not necessarily desirable. Before turning to those submissions, may I recognise the intense hurt felt by Mrs. Dove and Miss Whiting's broader family. The Secretary of State has previously accepted the criticisms made within the independent case examiner's report. They accept failures identified as serious and should not have occurred. The DWP doesn't dispute the conclusions, and where recommendations were made, those have been accepted.
Have they apologised for what they did and didn't do?
Yes.
Okay, so Mrs. Dove has had an apology. Right.
My Lord, I respectfully adopt the submissions that have been made by Mr. Hoff, King's Counsel, on the second ground in the appeal. I don't seek to repeat what he has submitted to the court, and I hopefully can therefore be shorter than the budgeted time. With your leave, I propose to address 6 short points, now shorter because of Mr. Hoff's submissions, which we say can be taken from the authorities. I'll then address what can be called the outside state detention custody cases upon which the appellant relies. I'll say a little bit about the destitution line of authority, where benefits and other civil rights have been excluded by the state. And finally, I'll address Lord Dyson's indicia res loci in this case. So my first of the 6 short points, or shortish I hope. The starting point is that the state does not own a general obligation to prevent a person committing suicide, even if the authorities know or ought to know of a real and immediate risk. And one sees that from Baroness Hale in Rabone at paragraph 100. I don't ask the court to turn it up, and it's repeated in subsequent authorities. Second general point we make is the operational duty will only arise in certain categories of circumstances. The courts following Osman have been clear that the existence and the scope of the duty must not impose an impossible or disproportionate burden on state agencies in carrying out their necessary state functions. Again, I don't ask the court to turn it up. Paragraph 104 of Rabone at Authorities tab 25, page 667. As a result, the operational duty has been extended on an incremental basis. The third, slightly longer point is that it appears, and is in fact common ground, that there is no case, domestic or European, that has extended the Article 2 operational duty to the present situation, which is to say, a duty on the Department for Work and Pensions or the equivalent state benefit agency in other countries to take steps to avert a real and immediate risk of a benefit claimant taking their own life whilst living in the community. Mr. Hyam, King's Counsel, yesterday spelled out the test that the appellant contends should apply. My note of that, and I read it so that I hope proceeding on the correct basis and not accused of getting it wrong inadvertently. If the particular circumstances are that the DWP knows of a suicide risk but engages in a positive act or omission, and then examples given, which reasonably foreseeably escalates the risk of suicide, and the DWP is the relevant state agency exercising authority and control in respect of that cessation of benefits, and has the responsibility for the individual's welfare when doing so, it's an Article 2 situation. Headline points in response to that, if I may. Firstly, that proposed test is one that isn't supported by the authorities, and I'll go to some of those in due course. Secondly, it is far wider in compass than any earlier case, and when considered against the facts of this case, as tragic as they are, demonstrate that it extends far wider. On its face, it wouldn't be limited to wrongful acts. As my lords and my lady explored yesterday in considering Dr. Turner's report on his evidence as it's understood, Miss Whiting's risk of self-harm and suicide was heightened whether one considers the actions of the EWP as being wrongful or not. And so it simply wouldn't be limited to the wrongful acts of the state agency. Fourth point, it would include, on the face of it, so a reaction to an otherwise lawful or correct decision. The fifth observation, one asks rhetorically, what is sufficient for an escalation of the risk of suicide? Specifically, how is that to be judged prospectively? We've explored difficulties in doing that forensic exercise after the tragic death of a person, but it's very difficult to see how that could be assessed prospectively when a decision is being taken. And the final point is that, as formulated, it is the DWP knows of a suicide risk, and of course the authorities tell us that it is no or ought to know. So in fact, I'm not advocating a broader test, but as it would have to apply following the authorities, it in fact, on the face of it, should encompass both know and ought to know, and therefore wider than has been put forward. The fourth and fifth points I can take very briefly, given what has been said, or perhaps what is not in dispute. In the absence of authority on the point, the court should address the question of whether an Article 2 operational duty arises by reference to Lord Dyson's indicia. And although those are not a sure guide, they don't give us the complete answer in all cases, they are the starting point for the analysis. And in my submission, the Divisional Court correctly applied those criteria. The fifth related point is that when looking at an extension of the circumstances in which the operational duty arises, the court should bear in mind and apply the Uller principle. And my lords, my lady, have been taken to the relevant cases, Gardner being a very recent illustration of that in application, also Morahan as well. The sixth point, I won't repeat what has been submitted by Mr. Hoff on Morahan, but I do stress the importance of looking at the risk that a body of the state, part of the state, is charged with. And it isn't a duty that sits in the abstract to prevent against all risks. I won't take the court back to the references to which you have been taken this morning. Can I then turn to the second area that I propose to address in submissions? That is the cases that arise outside of state detention. I won't go through all of them, and I won't propose to go through in any detail, but I'll see if there are questions from the bench, then I shall seek to answer them. But on illness, that perhaps if it's if I could turn up actually tab 11 in the authorities fund. I won't go through the detail because the court, I know, will be familiar with it, having looked at it previously. But turning to paragraph 71, if you may, at page 165, behind tab 11. So one sees there the court saying in the second subparagraph, the court considered this obligation must be construed as applying in the context of any activity, whether public or not, in which the right to life may be at stake, and a fortiori in the case of industrial activities which by their very nature are dangerous, such as an operation of waste collection sites. We submit it's also significant if one reads on in the court's judgment to paragraph 98, which is at the bottom of page 171. So the court said, to that end, the court considers that it should be begin by noting a decisive factor for the assessment of the circumstances of the case, namely that there was practical information available to the affected inhabitants of certain slum areas of an area were faced with a threat to their physical integrity on account of the technical shortcomings of the municipal rubbish tip. And the court goes on, paragraph 102 to 104, to explain the steps that the state have taken to disregard the warnings that have been given to it, and also that the state's policy towards condoning the risk in proximity to the slum area and the policy in respect of that were significant. I don't propose to go through the detail of the case, save perhaps to answer one of the points that my Lord Justice Lewis raised yesterday. If one turns to tab 21, perhaps making good the point about vulnerability and control. So this is the care home case. Paragraph 20, page 459, taking the statement of facts and grounds, referring to the individual as being an intelligent lady, who knows the defendant has made a decision to close her care home, however is unable to remember details, such as what she has ordered for lunch the previous day. Her memory is insufficient for her to retain and weigh up competing options. So in addition to being an elderly lady, on the face of it, perhaps lacking in capacity. So in a residential care home owned and operated by the City Council, in circumstances where, on the face of it, perhaps incapacitous. And so my submission, an analogous position to being essentially in state detention.
I wouldn't call it detention in a care home. You forgot to mention in state care, in state control.
Yes.
Detention is a harsh word to use for the elderly.
Yeah, I was saying by analogy from from residence in a care home to state detention. I take that.
Yeah.
Kemaloglu again, perhaps at a point of the detail which illustrates why, on the facts of that case, the court found Article 2 to be engaged. If one turns up tab 28, so this is the primary school which closed in a snowstorm. One can see at paragraph 19 to page 723. The court provides some relevant information about the deceased's particular circumstances halfway down that paragraph. The court also obtained expert opinion from a psychologist who stated that a 7-year-old child...
Sorry, which paragraph are you?
Paragraph 19.
Thank you.
That a 7-year-old child could not be expected to find effective solutions when faced with extraordinary situations. In this connection, she stated the child could not have foreseen the dangers he would face when he tried walking home alone in the heavy snowstorm. And then picking the point up at paragraph 35, where the court sets out its assessment of the general principles. Again, partway down the paragraph, in this connection, the court considers that the state's duty to safeguard the right to life is also applicable to school authorities who carry an obligation to protect the health and well-being of pupils, in particular young children, who are especially vulnerable and under the exclusive control of the authorities. So cases which take us back to control as being a decisive factor. And then
you have to read, the circumstances. He'd gone on the school bus to school that morning, and there was a snowstorm. Well, it was the day before there was a snowstorm. The Education Ministry took the decision to break schools up a day early. The little boy had gone to school on the school bus, and he was 7, and they then closed the school and didn't tell the bus, and they let him walk home. That's what, and he died. He froze to death.
Yes. And my point is that looking at the facts of the case, one sees, similar to what somebody who is unable to make the decision for themselves as to their own well-being and safety. And secondly, to take matters back to the question of control. And the school in this case had control of the 7-year-old child. The final case on this line is Mammadov in Azerbaijan, which is at tab 27 in our second level authorities. Noting that Mr. Heim yesterday described this as his key case. In that context, I won't repeat the facts which my lord went through yesterday, which are summarised in the headnote. They are, on any analysis, extreme. 25 to 30 police officers with batons. Mr. Hoff's taken the court to paragraph 101 earlier. Can I take us to paragraph 114, which is at page 709? So the court notes that there's a general rule in a police operation with the aim of eviction, which it was in this case, as in any other police operation, the police are expected to place the flow of events under their control to a certain degree. Moreover, in the present case, the deceased's actions, however unpredictable and reasonable they might have seemed, constituted a direct response to the state agent's demands and actions. And then at 115, the point that's been made, the court considers that in a situation where an individual threatens to take his own life in plain view of state agents, and moreover where this threat is an emotional reaction directly induced by the state agent's actions or demands, the latter should treat the threat with the utmost seriousness as constituting an imminent risk to the individual's life, regardless of how unexpected. So, again, extreme facts, but going back in this case to control being, we would say, the gravamen of where this obligation arises. And of course, to the extent that Mammadov in particular is relied upon, that of course was a case considered by the Supreme Court in Warby, and the court didn't define the operational duty in the wide terms intended. Briefly on the cases on benefits, I refer to paragraph 35 of the appellant's skeleton argument. I think I can take the point briefly. In my submission, they don't disclose a clear and constant jurisprudence from the European Court that would justify the duty as contended for. May I then turn to the destitution line of authorities? The headline point in response is that these are cases concerned with the immediate effects of leaving individuals in destitution. Mr. Hoff has taken the court this morning to Morahan in the Court of Appeal, paragraph 15, which makes the point, and it's repeated in other cases, the duty is to protect against particular risks to life, not all risks. And so one has to be careful about reading across those destitution type cases to the present situation. I won't go through the facts of the cases, but in my submission, that was when the court considers these authorities, it is clear that these are cases of extreme material poverty, the phrase used in MSS in Belgium. In VM in Belgium, the court noted the particular vulnerability of the applicants being asylum seekers and children. And in Limbuela, one only needs to consider perhaps the summary of the facts in Lord Hope's speech from paragraph 19 to 32 to see the extreme nature. And in my submission...
But isn't this pretty extraordinary? This is a woman who can't work. There's no other means of earning what you need to live, to pay the rent, to buy food. And as I understand it, when they cut off the support allowance, the other things too, the council tax benefit and the housing benefit won't.
Well,
everything won't, I thought.
I'll be careful on the evidence, because this is an appeal. B, first instance, we for reasons entirely fault on our side of the court, we weren't able to admit evidence on it. But we understand that actually it isn't the position that all other benefits were ceased. It isn't quite as stark as that. But in my submission, even on the facts as advanced by the appellant, it isn't of a similar nature to the destitution type cases. I would also submit that a feature in Limbuela, and it's picked up in the European authorities, Lord Brown, paragraph 94 at page 244, the subjective intent of those responsible is a relevant consideration. Was the intent to humiliate and debase? We say that on any analysis. However grievous the failures in this case, that is not the position. As Baroness Hale makes the point, it is a high threshold ruthlessness and cashlessness, as she puts at paragraph 78. And then a final observation on that as to why it is not applicable. a feature of those cases was that the policies were intended to operate indefinitely. They were state policies to deprive rights on a permanent basis. As Mrs. Justice Farby set out at paragraph 78, in addition to the mandatory reconsideration, there is also appeal rights against decisions of the benefits agency.
The mandatory reconsideration didn't work because Jodie did write in, but the decision didn't come until after she died. And when the decision came, I think it was the 25th of February, after she had died, it was still no.
Yes.
It was only when the mother sent another copy of the letter from the CAB, which is in about March, I think, that the decision was changed.
I accept that.
So the mandatory reconsideration doesn't seem to be something that would have been likely to have altered anything. So it is the appeal rights we're relying on, is it?
Well,
and what are they? Would you go to the first year tribunal, do you? And
yes. I don't push the point too far for the reason that my lord has identified. But in distinction to the policies that were being considered in Venezuela and the Belgian policies in the other European authorities, the decision to withdraw ESA was not an indefinite one, is the point that I make. Yes, can I just finally, I think on that, take the court to the Palestinian Authorities case, which is at tab 40 in the second appeal authorities bundle. We went to paragraph 60 onwards yesterday.
yeah,
But I note partway down paragraph 61, where the court is discussing the range of administrative decisions which might have to be reconsidered and reversed in the scenario as it was presented. It is obviously wide. And then the first example given, with decisions as to benefits payments, and then going on taxation, housing, immigration. And then reading on to the subsequent paragraph 62, in my judgment, no obligation to review administrative decisions in such circumstances will usually arise under Article 2. The state body undertaking such administrative matters, such as the Home Secretary in WA's case, will not have assumed responsibility for the welfare and safety of the patient, and will not have a role in addressing the aspects that render the patient vulnerable. And then noting that in WA's case, the NHS would have had its own duties. There are certain parallels with the present case, in that we know, and I don't ask the court to turn up the references to the inquest transcript, but we know that on the 15th of February 2017, Miss Whiting attended both the CAB, the Civil Advice Bureau, as well as her GP, and then on the 19th of February, in the presence of police officers, Miss Whiting said that she felt like doing herself in, and the police offered to take her to the Rosewood Park Hospital, a mental health facility, but Miss Whiting declined to do so.
how do we know that from the evidence? I know that she went to the hospital because she telephoned from the hospital to the DWP, but how do I know that the police, from the evidence, that the police took her there? I'm not saying they didn't,
I think that the evidence was didn't do so. So if I could take the court to page 299 in the core bundle, it's towards the rear.
Yeah.
And then it's line 29.
This is the letter from Mrs. Dove, I think, that she sent in March.
Yes.
Oh, the police were there, yeah. Mrs. Dove was, yeah, okay, I see that. I'd missed that, yeah.
So perhaps the point being that certainly the DWP's decisions need to be put in their context, and they're not simply the only state agency involved in this matter.
No, but there's nothing flawed with the police. I thought you were going to say, but you're not saying, that because Jodie went to the GP and the CAB, she could have gone to the medical assessment. The problem is she never opened the letter for the assessment because of her mental health. She couldn't deal with the post, which is something that's not uncommon with.
Yes.
It's just that the police, that's not what he's saying for once, it's just that the police were there as well, but they don't really feature.
Can I then turn to the three indicia? Assumption of responsibility. In doing so, I bear in mind that we're not construing legislation in the sense of science. But this is the guide to what we think should apply. Assumption of responsibility. The legislative scheme for the assessment and payment of employment and support allowance is set out in paragraphs 7 to 10 of the Divisional Court's judgment. In summary, ESA is only payable where an individual has limited capability for work. That limited capability arises as a result of physical and or mental health issues, which means that it's not reasonable that that person, reasonable to require that person to work. My Lord Justice Lewis asked yesterday whether it's known which people are placed into the support group. We find the answer to that in paragraph 8 of the judgment, which itself is derived from section 24 of the Welfare Reform Act, that a person is a member of the support group if he is a person in respect of whom it is determined that he has or is to be treated as having limited capability for work-related activity. And that goes back to the definition that I've just outlined, that it's a capability that's limited by physical and mental condition, and the limitation is such it's not reasonable.
Well, it's the first group, you're returning them to work. The second group that Jodie was in are the people who, because of their physical or mental condition, are not capable of carrying out work.
Yes.
But that's assessed for 2 years and then reviewed after 2 years.
Yes. ESA is only one of a number of benefits administered and paid by the department. Very many people receive ESA, many of those who will have profound physical and mental health needs. In that context, I invite the Court to note paragraph 34 of Mrs. Justice Farby's judgment. The DWP interacts with around 20 million people a year. Neither the regulations nor the policies and procedures we submit amount to an assumption of responsibility by the department to prevent a recipient of ESA from taking their own life. They no more establish an assumed responsibility than the many comparable statutory and non-statutory procedures applicable in clinical contexts. In my submission, the weight that is placed upon the policies doesn't make good the point that the appellant seeks to make. And perhaps one can see that from the document in the supplementary bundle behind it's tab 2, page 88. And this perhaps illustrates the breadth of individual and issues which the department will be engaged with. So vulnerability instructions, paragraph 2 of page 88. The DWP, I'll wait for my little turn. For DWP purposes, the description of vulnerability is an individual who is identified as having complex needs and or requires additional support to enable them to access DWP benefits and use our services. Skipping over paragraph 3, paragraph 4, complex needs are difficult personal circumstances and or life events that affect the ability of the individual to access DWP benefits and use our services. So the definition of vulnerability in my submission is very broad, and one ought not to read too much into a policy concerned with vulnerabilities where...
I can say two things. One, you can't assume that the fact you're on the policy covers you means you've got a risk of suicide as opposed to other things. And secondly, it doesn't amount to an assumption of responsibility.
Yes. So in our submission, the DWP didn't exercise any sufficient control over Miss Whiting. And perhaps that's illustrated by the fact that the 15th of December letter, to which my Lord Justice Lewis has already referred, from the Centre for Health and Disability Services wasn't open. Contrasting the sort of control type cases where an Article 2 duty has been found, it perhaps illustrates the arm's length nature of the contact that was had.
Sorry, what the letter? Can you just give me a reference?
So this is the letter that was sent on the 15th of December that was unopened.
Yeah.
Okay.
And again, a bit hard to ask you this, but I'm going to anyway. Why not? You're there. You've taken us to a disembodied document about vulnerability instructions, but we've also got pages 84 to 86. We've got the fact that Jodie was in the support group, and there's a mental health flag, I think it's called, there. And of course, I'm sitting here thinking, well, what exactly is the mental health flag? What triggers the attachment to it? Yeah. And I looked yesterday evening at 84 to 87, and I couldn't see much in the evidence before this court, and that's all we can proceed on, to show what the mental health flag covered, whether it's something that covered all the vulnerable people or a subset of the vulnerable people, or whether it was something that you attach a mental health flag for those who are suicide risks. I couldn't see anything here.
Yes, I can't offer up the criteria for which the mental health flag is applied, save to submit that it applies to a broad spectrum of cases, from the most serious and severe mental health issues to those which are less severe. And yes, well, I don't seem to give evidence on the point.
That's the only evidence we've got. And you say you can only say a broad spectrum. I just looked at 84, yeah. And that refers to it. But where's the evidence to show that maybe we've got no evidence, but where's the evidence to show that it's serious to less serious people with mental health problems?
There isn't any evidence from the court. So
we've got to infer it from what we've got.
Well,
there's no evidence to say the mental health flag is limited to suicide, and it's something that's connected with non-attendance and mandatory interviews.
Yes, I certainly submit that it's not this person is at risk of suicide, therefore we tick the mental health box.
And how can you submit that if you haven't got the evidence? There's nothing to say.
I hesitated because I didn't have evidence.
You say there's nothing to suggest on the evidence that it is limited, and you're just responding. There's nothing to suggest on the evidence that it is limited.
Correct.
Right. Okay. I wonder what the questions were that Mrs. Varney asked.
I think we have some of the exhibits to the statement.
Yeah.
Yes, the FOI request.
Yes. She asked for 81. I request information in relation to safeguarding law and claims with mental health problems. So it wasn't limited to suicide. That was the question. And then affect their day-to-day activities, mental health issues. But that seems to be broader. And then your response at 82 is guidance to staff on how to deal with vulnerability customers, and that's the ones you've shown us. Then the DWP is supposed to telephone before they make a decision.
Yes.
So all of this material that you provided is in response to mental health claimants, which is presumably where you get the inference that this is people dealing with mental health problems, broad to serious, not a particular subcategory.
Yes.
Yeah. It's based on the request information.
Well, I think it's fair to say I don't know the precise origins of all of these documents. I think the statement which the court was taking yesterday referred to research conducted otherwise. So I can't say, although this on the face of it would appear to be an internal document. So on the face of it, it's I infer part of the FOI.
Let me just then see what you're quite right. Evidence is important. I'm just trying to just find the description of MV2.
It's paragraph 15 of the statement of page 72.
Okay, yeah. So we don't know whether your department provided the documents in response, or whether Miss Varney did her own research afterwards.
My inference would be this particular document looks to be an internal document. I don't have instructions on that, but on the face of it, it looks like an internal document concerning how things will be done, should be done.
And if you say it's an internal document, are you implying that that was then provided to Miss Varney following her request, not that she hasn't got it off the internet or somewhere? Or are you saying we just can't tell?
On the balance probabilities, I would assume it is a response to the FOI.
Right, okay.
But I don't have instructions on that.
No, I understand that, and that's why I said it was unfair, but I did it nonetheless.
No, I hope I've tried to answer it as best I can.
We're very attached to evidence. We are a court.
Yes.
Thank you very much. That's very helpful. Now,
conscious, I can take the following letters briefly. I've dealt with one of Lord Dyson's indicia. If I'm just touch on the second and third, or perhaps just final one first. Given the duty contended for, we submit that the DWP is simply not resourced or empowered. That's empowered, more importantly, resourced for present purposes, to exercise the degree of control over the lives of people who receive benefits in a way that is contemplated within the authorities. On the second of the indicia of vulnerability, as has been submitted and is reflected in Mrs. Justice Farby's discussion at paragraphs 83 to 84 of the judgment, Ms. Whiting suffered clearly from a number of physical and mental health issues. However, that is true of very many recipients of state benefits, in particular ESA. Avoiding what Lord Roger described in the Savage case as an auction of comparative vulnerability, when one looks at the other authorities, in my submission, Ms. Whiting wasn't in the category of vulnerability that the courts have hitherto found to be required, particularly outside of closed communities. She was living independently in the community, not suggested that she lacked capacity to make decisions for herself. And as a variety of cases make clear, and Maguire in the Court of Appeal being just one recent example, it isn't sufficient for the purposes of establishing an operational duty that an individual is vulnerable, whether by reason of physical or mental health issues. Perhaps also on the policy and safeguarding point, the court was taken yesterday to the Kent case. This is the 14-year-old boy where there was some measure of responsibility by the local authority, the words of the court. Undoubtedly, there would have been a plethora of safeguarding policies in that scenario. Nature of the risk, finally. Again, undoubtedly the case that Ms. Whiting had long-standing mental and physical health issues, a history of self-harm and suicide attempts. Again, though, that is not uncommon, sadly, in those who receive benefits of this kind. In our submission, the risk posed, for the reasons found below, Ms. Whiting was not in the exceptional category of situation as contemplated in Rabone and other cases. We also submit that the withdrawal of benefits is not the sort of inherently dangerous activity contemplated by the courts in other cases. And so this would be we submit a significant extension. Finally, it would be wrong to say the DWP created the risk of his wife taking her own life, given those enduring and chronic conditions. Finally, we say the court was right below to take a step back, to consider matters in the round, and come to the conclusion that Teague. We submit that the proper application of the indicia supports the conclusion below. Unless I can give any further assistance, those are my
No, again, thank you very, very much for your help. Oh, sorry.
Incoming.
Yeah.
I just wanted to check, if I may, Mr. Dixie. I've got your submissions on ground 2. That's very clear to me, at least, and thank you very much. Ground 1.
Yes.
Are you neutral? Is that how one would describe? So you neither support nor
Yes.
oppose
Yes.
the proposition of a second inquest on common law grounds?
Yes, we don't make submissions on ground 1. We have nothing to add to what has been submitted.
But you don't support or oppose either
No.
side. You're perfectly entitled to be. I just want to make
Yes.
sure that we've understood. We
Hopefully
have
not-
had
I've
quite
got-
a lot of discussion, sorry to cut across you, but we've had quite a lot of discussion in this court on which I invite your observation about what might occur at a second inquest. And obviously the DWP would be invited by the coroner to participate in that inquest. So I just ask you, for completeness sake, and you may not have instructions, and I quite understand if you don't, but I think there are 2 aspects. One is if you were invited to participate in the inquest in terms of the fact-finding of that inquest, would you wish to be heard on fact-finding?
I don't have instructions, but I anticipate we would do so, yes.
You would do so.
I anticipate we would do so.
To challenge, I mean, where do we sit on the psychiatric evidence? You've said to us that you accept Dr. Turner. Does that mean that you wouldn't anticipate calling your own
Well,
expert?
except the ICE report. Dr. Turner
Okay.
is not something that we have explored or looked at.
Okay. So
When
that
you
would
say
just
you
be out there.
accept the ICE report, we need to be very careful. Within the ICE report, there are different legal categories of things happening. There are facts found. The DWP did not telephone Jodie. There's also facts found the other way, that for whatever reason, tragically, the letter from the CAB, there's no evidence that that was received. I've assumed that the reason why there's not going to be fact-finding at the inquest, if there is an inquest, we haven't decided yet, is because you accept, when you say you accept the ICE report, you accept the finding of facts, and you're not going to turn up and say, oh no, we made 6 attempts to call, but we couldn't get through. I mean, that's not going to happen, is it?
No.
Right, yes. Okay,
It is
so the
accepted
facts
fact.
as found by the independent case examiner will be the facts.
Factually, and the criticisms
And the criticisms, right.
accepted.
So, sorry.
Yeah, thank you very much. So I've got that on the ICE report. Where were we on Dr. Turner, who of course piggybacks on the ICE report?
I don't have instructions on what would be done. I anticipate there would be little scope to add to what Dr. Turner says, to challenge what is said.
And then the
His
next
conclusion is what it is.
Yeah, indeed. And then the other part of there's maybe a full separation, but it's easier just to ask it in this way. There was also discussion about the possibility that DWP would want to be heard on sort of remedial measures that have already been put in place, because that is quite often part of that's a focus of a coronial inquiry. Do you know what the DWP's position would be in relation to that?
I don't have instructions on that, but I would anticipate we would comply with any request by a coroner. Often a request is made for evidence through a statement addressing prevention of future death issues. I don't anticipate that would be resisted. It would plainly be within the coroner's scope if such matters were found by this court to be within the scope of any future inquest.
Okay, well, thank you very, very much. You've been, again, very, very helpful and very, very patient. We are grateful. Now, Mr. Fernando, you were not going to make oral submissions. You're really here to have a watching brief, in effect, for Dr. Rahman. Is that right?
My lord, that's
So you don't
entirely correct.
seek to make any submissions?
No, there aren't, my lord. My only observation, my lord, is in respect of the ICE report. I think my friend Mr. Hoff, his counsel, has addressed that. paragraph 64 of that judgment deals with the Jordan requirements, so the minimum requirements for a compliant investigative duty, but also very helpfully, Mr. Justice Garden, paragraph 84 sets out what is not required. So those paragraphs may be of assistance.
That's helpful. We'll make a note of that. That's really helpful.
Sorry, was that the garden?
It's the guard 84 of gardening.
Grice case.
Sorry?
Grice.
Oh, Grice.
Grice,
So the case is Grice against Her Majesty's Senior Coroner for Brighton and Hove.
We've got that, have we?
I don't think that's in the authorities bundle mode.
Okay.
The exact reference is 2020 England Wales High Court 3581.
Thank you. I'd heard Gardner.
Grice.
I was making the comments about getting a bit old earlier on. I'd heard Gardner, but it's Grice. I beg your pardon.
It's in fact a case, Mr. Casey was involved in.
Yeah. And it's GRYCE, is it?
GRICE.
Oh. Right, so that's Grice. Yeah, bear with me. That's helpful. As you clarified two things for us at once. Thank you very, very much. Right. Nothing else. So, Mr. Hyams.
Thank you. Well, by way of reply, what I propose to do is deal with Article 2 first, if I may, and then go back to round 1.
We thought it'd be half an hour. We had half an hour for slippage. So we'd be happy to carry on, say, to 10 past 1, if that would help. Unless you think you couldn't finish this morning, but take as much time as you need.
Well, the only point with as much time as you need is just about the Grice point on that sub-issue that's been raised by the court as to the participation in the investigation, the ICE investigation. Because certainly, without question, our case is that quite a detailed submission could be put in by reference to that case in answer
To what I asked, yeah.
question about why it wouldn't satisfy if Article 2 applied.
So the lack of family participation
The lack of
is
family
not enough because
participation.
Mrs. Dove and the family couldn't do anything before ICE,
Indeed.
having started it.
And there's quite a lot of case
and
law
you say
about
that. Well, I remember Jordan actually. So you say it follows from Jordan, so I think that probably deals with that.
Well, can I try and make some short points first then about Article 2 and picking up on your Lordship's point about what the DWP does, as I say, it administers benefits in accordance with the regime laid down by Parliament. Our case is about how they go about doing that, the process of administration, and that through the positive acts or omissions taken by the department in relation to the administration, they both learn of a risk of suicide and by their actions escalate or may escalate or increase that risk of suicide by not following appropriate procedure. And I completely understand the point derived from the authorities to say it's about a particular responsibility in respect of a particular individual, in respect of a particular type of harm. There may have been a duplication slightly in the way I've expressed it. We accept all that. Our case is focused on a particular sphere of responsibility of the DWP in its administration, in a context where it takes a positive act and or commits certain omissions, knowing of a real risk of suicide or risk of suicide flagged on their system told to them, in circumstances where it knows by reference to its own procedure that act or omission may increase or escalate the risk.
Knowing what?
That their act or omission, but if you mishandle.
So it's knowing that their act will increase the risk.
Yes, ceasing total cessation of benefits for a highly vulnerable person, it is reasonably foreseeable to the department that may have dire consequences for the individual and put them in a state of desperation. And that is an area of, in inverted commas, control, such as that the state has assumed that very narrow, but nonetheless important degree of control and responsibility. And that's our case. And may I just give you one point from the authorities. In MSS and Belgium, the case referred to, case about destitution. It's been repeated, well, destitution, and it's been said against me, well, that was weeks of destitution being left out on the street with so-and-so. But what's important about why it was a breach of Article 3 is to be seen from paragraph 263 of that decision, which I think is my notes.
Tab 23.
Attached with that.
No, it's not.
482.
Tab 22, sorry. And paragraph 263?
I'm 263 I'm aiming for.
Yeah.
Yeah, thank you. If I could just pick up the words in the middle of that paragraph. The court considers that the applicant has been the victim of humiliating treatment, showing a lack of respect for his dignity, and that this situation has, without doubt, aroused in him feelings of fear, anguish, or inferiority, capable of inducing desperation. And I suppose the point I take from that, I don't suppose, it is the point I take from that, is that in this particular circumstance, in fact, our case is worse in one sense, because there it said, oh, well, it lasted for 4 weeks or so, and it was terrible for the individual. In fact, the cessation in our case, because of the shocking failures, was that she was pushed into a mental state of total desperation, such that she took the ultimate step and took her own life. And the linkage between that decision and state responsibility, we say, is sufficient by reference to the control that is operated by the DWP, both in requiring a face-to-face assessment, as they do, and the way they handled, I'm not going to go through it again, well familiar, the process between September and her death. And that control does include requirements to submit documents, to attend for interviews and so on, all of which we say should have. That's that point. Two other short points on...
Mr. Hine, sorry, and I'm conscious of time, I know, but that is potentially a proposition of broad application, isn't it? Because in this case, something went wrong, leading to cessation of benefits. But as really what you're saying is if you're going to stop the benefits from somebody who's peculiarly vulnerable like this, that you're into the territory where you might have an Article 2 operational duty. And that could be whether you're doing the right thing or the wrong thing.
Well, my answer to that is I'm not arguing for this wide-ranging COVID-type Gardner, every recipient benefits open to risk. And that's the argument that's clearly put against me. You're going to open the door. Because I do focus on the wrongness or the wrongful.
It doesn't matter.
May I just try and explain why I said it may matter, or it should.
It may matter.
In Mamadov, what is advanced is that there are a large number of police officers exercising a degree of control, and the poor lady took the decision for herself, but pour kerosene or whatever it was, and so on. And the way that was mishandled, that was at the focus of that finding, the mishandling by the police of the situation, totally unsympathetic, failing to respond, failing to recognise it as on the facts it failed. And so I say it does matter.
So just to put that into logical terms, there's no duty owed generally, but if they mishandle it at that stage, they owe a duty.
If they mishandle it in circumstances in our particular, where they know of the risk of suicide, they know because of their guidance that their actions may escalate that risk, and they mishandle it, then you have a particular set of circumstances where the operational duty may engage because of the underlying degree of control. And may I just make 2 points on the cases that were touched on. One is, just in the submissions just made by Mr. Dixie, Kent was mentioned as an example of cases, well, Kent County Council probably had policies. In Kent, of course, the court thought that they were in the territory.
But there was no duty.
But there was no duty because no real immediate risk. In Mitchell, which one of Mr. Hoff raises, again it said, well, the police might know that sort of duty, but the local authority didn't on the facts, but the local authority probably had some policies and procedures about what to do if you're subjected to violence and so on. They probably did, but in that circumstance, the particular risk which wasn't caused by the local authority, whereas here, let's say the threat from others, whereas here, our case is that the particular risk in question was caused by the maladministration, perhaps the first word, the manner in which the administration of the cessation of benefits occurred. And that is a distinction, an important one, why we fall within the clear, constant jurisprudence to the effect that in particular circumstances where there is assumption of responsibility, at least of a degree, plus the vulnerability, plus the risk is such, in Desir, it flows with the jurisprudence. That's essentially the case. If I can then say in relation to ground 1,
Yep.
At the end of the submissions of the Assistant Coroner, I think the position was reached that it was agreed that there is no case that says that which we argue for cannot.
No case saying you can, no case where it's been done.
Yeah, no case saying you can't. That's my first point. And it was said, well, first principles should be applied. I therefore feel it's necessary to show applying first principles why the arguments put forward by HM Assistant Coroner are wrong or not right as to what's permissible and impermissible. I would say at once that I agree and endorse the observations already made by the court about elevating what is essentially a statutory discretion of the coroner into a rule of law. And the thrust of our case is that it is ultimately a question of coronial discretion, how wide the inquest goes, and what to put in the box 3, what to put in the box 4. Remembering, of course, bullet point, really, that there's a 3-step process, including the findings of fact stage, which is set out. All of that, in fact, postdates, all that guidance about the findings of fact stage, postdate Hurst. You see it happen in Worthington. There's a long review of the facts, almost like a judgment, setting out the facts, setting out failings. And that can be done entirely permissively. And so it's important to remember in this thinking about, not to remember that there's the investigation that goes on in the inquest and what ends up in the box at the end. Because that investigation will produce factual findings in any event, or should do, on the key issues out of the inquest. But with that said, in general terms, we say there is no statutory provision in the 2009 Act which postdates Middleton and Hurst that prevents a narrative addressing factual matters relevant to the formation of intention in a suicide case. That's point 1. Allied to that point, it is entirely proper for the appellant to argue by analogy to other cases, not necessarily suicide cases or self-inflicted harm cases, not least for reasons identified by HM Assistant Coroner, including that motivation will be relevant in other determinations, such as he identified death by mere misadventure. Second point, it would render if there was a legal rule prohibiting that which we argue for, it would render the public record inadequate. And a good example of that is the Worthington case, because it would fail to record the facts, the sufficient factual findings that are necessary to be recorded in the inquest. The third point is that Hurst is not, we say, underlined in red, authority for the proposition that the coroner cannot make findings in relation to causation of the state of mind or intention. It does not support that proposition. And indeed, without going to them, may I just give you Lady Hale's paragraphs in dissent at paragraphs 21, 23, 20, 21 and 23, and what Lord Brown says at 27. And you will not find in those paragraphs the cannot or the prohibition that is argued for. Fourth point, I hope I'm not overcounting or undercounting, the, in inverted commas, physical means of death phrase is a gloss to be found in Cairns. It is not the gloss of Mr. Justice Silver in that case, and the relevant paragraph is...
Sorry, which case are we on with?
In a case called Cairns. It's a case referred to by HM Assistant Coroner in the skeleton, and where the word physical means of death is used. Now, actually, it's I think Mr. Hoff here, but if you look at the Jameson, no word physical is to be found, and it is a gloss that was a road traffic accident case, and it may be understandable. But as a matter of law, there is no physical, psychological divide. No one has said it must be limited to the physical means.
It's how, i.e. by what means.
Indeed.
And you start with the medical, well, I've started with the medical causes, the machinery, if you like, by which life ceased. And then there's the how, by what means did that come about?
Indeed. And it's just what, how, by what means.
So basically, we mustn't get too hung up on words. We must remember to go back to the statute to not introduce words that judges loosely bandy about, thinking they're being helpful when they're usually not. And you're too polite to say, yes.
Yeah, I would never have said that.
No.
But, that is our tradition.
That's it, basically, in a nutshell.
Sorry, I didn't mean to that's all after much. The paragraph 4, I'm now on a different point, which is helpfully to you. This argument is engaged with by the Divisional Court in Worthington, and the relevant paragraphs. I'm keeping one eye on the clock. If you're willing to keep going,
we're happy to. It's probably better to keep going till about 1:15. I'd have thought.
How long do you think you're going to be? I mean, will you get there? Do you think by then, or if you're going to be longer, then we.
If you're going to be longer, we'll stop. But we don't want to put you under any time constraints at all. Why don't you keep going to 1:15 and see how we go? We'll try not to intervene. Yes. So Worthington.
Sorry, thank you. Can I just give you the paragraph rather than?
I mean, we'll read Worthington again. Don't worry about that.
But the important point in Worthington, which is to be found in our, it's relatively recently at 859. This argument is engaged with in particular, picking up from around paragraph 42. So there is also comment about McDonnell, another case relied on. The brief point, if I can reply on both McDonnell and the Gwent case, those are not fresh evidence cases.
No, they're not.
And you can see that McDonnell isn't at paragraph 48, where it is recorded Mr. Daniels does not rely on fresh evidence. At paragraph 42, there's 42 I can to emphasise the following paragraphs, if I may. 40, 41 in particular, the last 3 lines.
Yeah.
This is the, sorry, that's the discretion point that
Yeah.
has already been identified.
It's 46 too, actually. It's the middle of 46 that we looked at yesterday. It is essential to explain why Poppy was in the unsafe sleeping environment which caused her death. I mean, the thing that caused her death was being in the, not being able to breathe, and she was in the bed. Why was she in the bed? Because what was being done to the poor child.
Yeah. Under 42, Hurst is directly addressed.
Yeah.
And the paragraph at 51, which repeats effectively the point already made in Hurst at 34, because I think Mr. Hoff took you both to paragraph 34 and 51, but the point is the same point. And the answer is, which we emphasise under the indented paragraph, is Lord Brown was there, merely emphasising that. Where Article 2 of the Court of Human Rights is engaged, the scope of purpose of an inquiry is wider than if it's not. He clearly doesn't intend to suggest that no exercise of judgment is required by a coroner in identifying the findings of fact that are deemed necessary for the determination of the matters mentioned in 5.1, including how, or the matters that should be recorded within the determination of such matters. And the reasoning continues, and we identify paragraph 46, where there's no fault, and I think I took you to that already, but particularly the first 5 lines of 46. And 49 addresses directly, again, some of the case law and the difference between scope and what Lord Brown has said in Hurst, and says in specifically, under the heading, after the first 3 lines of 49, we reject the suggestion that the scope, even in James, is particularly narrow, and then it continues. And I just invite you to read the whole of that paragraph or note it. The final 4 lines, we are unconvinced by Mr. Thomas's submission that it's sufficient to record such findings in a ruling, and that a coroner is, in the circumstances of this case, positively prohibited from including the determination of the how question. And then 50 and 51 in addition. And the points made at 51 is about the impropriety of the court trying to micromanage or constraining the proper discretion of the coroner to the answer to the how question. So that's really the court's point already about, aren't we elevating appointments discretion of the coroner, something else, and that's combined with my point. There's no argument. Sorry. If the coroner were so prohibited, it would significantly neuter the coroner's role in avoiding repetition or the prevention of future death, if there was a prohibition on it. Because using the record of inquest as a means of bringing to public attention matters of concern is a vital function of the coroner.
Yeah.
Insofar as it's said against me that, well, usually one doesn't need to, we've given examples.
It doesn't matter, you say the fact that it's possible, even in one case, shows there's no statutory prohibition.
And I've referred also to, and I think I've made the point already, the 3-stage approach and the findings, and you'll see how, and again, Bobby Worthington, the court wasn't too excited about the distinction between whether it's found in the factual findings or in box 3. And so insofar as one has to be a bit careful in arguing from, well, because you couldn't change box 4, therefore there's no point in having a further inquiry.
If you can do it, you must be able to put it in a box. It's the short answer. You can't have computer says no. If law says yes, computer's going to have to be made to do it.
Indeed. And there's, insofar as paragraph 34 of Hurst is relied upon, the worst of all possible worlds. It certainly is not post 2009 in the Coroners Act, put on a statutory footing, what needs to be put in, plus the coroner's guidance and the three-step approach. It is not the worst of all possible worlds to have an inquest where the proper facts are investigated, causal link is investigated, and factual findings are included, including in relation to state of mind and the formulation of that state of mind, if the public interest requires it. It being open to the coroner, as a matter of discretion, to say no. May I just take some?
Yeah.
Take
Yes, you check with Mrs. Dove in particular.
May I make a completely different point than I was going to make, and I'll make this fun point after. It's just one thing about, you'll see how, I think in Worthington, doesn't matter, oh, sorry, Davidson, there's a question as to whether it should go back to the same coroner. And that's an issue, and when we've been, the discussion...
Well, if we get to that, we'll get to that. My initial reaction is because the coroner's been so heavily involved, without any criticism of her, it would be unlikely that it would go back to the same coroner, but we'd have to think about that, actually.
If it helps, without even any direction, I'm sure that the senior coroner would be happy if there was another inquest to allocate it to herself or to
It's not a criticism. Often, if somebody looks at one of my judgments, it's sometimes better to say, no, let somebody else do it with a fresh mind. It's not a criticism, but we are only human, actually.
Yes.
Yeah.
So if we get to that, it's likely to be another coroner, a different coroner.
I suppose the only other thing...
That would be more likely to be in the order, I suspect, but we'll see. It could be in the judgment, yeah.
But the only other thing I would say is in terms of evidence, because sometimes it's been a little unclear, and this is not a criticism, but which points are being raised neutrally by HM Assistant Coroner as her points, or which are legal points. She has put a statement in this case, a very short statement, approving the initial skeleton. I don't think there's any other evidence about that.
But there are things in the skeleton that looks like instructions masquerading, evidence masquerading as instructions. But I don't think we need to go there. We've got the point. The key question is, if there's going to be a new inquest, whatever, without any criticism at all, is it better that somebody looks at it afresh, or is it better to go back to the same person? And to be honest, that's something we'll have to decide if we get to the fresh inquest.
Well, can I just leave the final point, and my junior raised it as a matter of concern. If this court was minded to determine is the Article 2 procedural duty satisfied simply because the ICE report's been carried out, there's a more detailed submission that we haven't made.
Right, well that's fair. So I raised it. I begin to wish I hadn't now, but I raised it. And what you say is, before I get too wound up with what I thought of yesterday, if we're going to go down that route, we ought to consider giving you the chance to put in a written submission.
Yeah, I mean, I'm not too excited about it, because I think ultimately where I'll end up is where I think the court has already probably ended up, that the absence of sufficient participation in the ICE report is by itself sufficient to mean that it wouldn't be satisfaction of procedural duty. But there's more that could be written on that.
So if at any stage we are tempted by what I said yesterday, we should resist the temptation and let you have a chance to say something more. Because it's only fair, because the other side didn't raise it. It came... sometimes it's better not to think, but I did. It's too late now. But what you say is, if before we go down the route of it was satisfied by either the ICE report or a combination of the existing report and the existing inquest, in fairness, you think you should have another...
Well, only because, were you to decide that at paragraph 124, not that you might be that long, but to a certain paragraph of your judgment, it would be unfortunate if you hadn't been addressed.
Well, it wouldn't be fair, you'd say. It's not even unfortunate, because you've got to be fair to everyone. And it wouldn't be fair if I thought of something, you hadn't thought about it in advance, nobody raised it, and then you didn't have a chance to comment.
Well, I have had a chance, but all I'm asking
Yeah, is a proper chance. Yeah, right. Let me just make a note. So, if adequacy, need for further submission. If we get to that stage, my colleagues will remind me about that, and we'll see whether we need further submissions. If adequacy, need for further submissions. Yep. Yep.
Yeah, I think that's it. Thank you very much.
Well, thank you again very much. You've been very, very patient.
My Lord, just before you rise, a point was made about the coroner's statement. Just to be clear, she made that statement because this is in former Part 8 claim. She had to put in a statement, verify the factual content of what appeared then in the grounds.
Right, okay. All right. Well, first of all, could we thank Council, please, for all their very helpful submissions, and also their legal teams for getting all these bundles in. It's more complicated than one realises to get everything in order. Secondly, could I thank the family? You've had to sit through sometimes distressing facts, and you've had a lot of legal argument. Lawyers will go on if you give them the chance. But can I just say, the one thing we have not forgotten is at the heart of this case was your daughter, Mrs. Dove Jody. We haven't forgotten that at all. We know how much she was loved by you and all members of the family. So don't think the lawyers have forgotten it. It's a lot of legal argument, but it was about a person who brought a lot of joy and love to this world. So we haven't forgotten that. Now, we're not going to give a judgment straight away because we want to think about what all these people have said, and we want to go back and look at the evidence in all these cases. So the procedure that we follow is we don't give judgment today. We go away and think about it. We'll prepare a draft judgment, which we'll send out to the lawyers, just to make sure we haven't made any obvious factual mistakes or typographical mistakes, and they'll comment on that, and that's confidential. And then we'll give our formal judgment in a written document, which you'll have to keep and which you'll be able to show to your family and to anyone else. And we will do that electronically these days. We don't need to come all the way down from Stockton and be in court. That'll be done electronically, and your solicitor will make sure that you get a copy of that in hard copy. So you will have a copy of our decision for you to keep and look at back home in Stockton. So thank everybody very much. We can't give you an indication of when it will be, but safe journey back to Stockton as well. And thank you all very much for your patience and your understanding.
Thank you.
Well, no, thank you, Mrs. Duff. It's been a pleasure for me. Say, I just wish it had happened in different circumstances. Yes.
It's not straightforward.